Hello, everyone. Welcome to the whys and hows to wage and hour law in 2021. I'm glad you can join us or join me in this half an hour presentation on some updates on wage and hour law. My first disclaimer is that our marketing team promised you a riveting presentation, and usually wage and hour law and riveting do not go in the same sentence, but I'm going to try to make this as entertaining and informative as possible. So let's get started. A brief background on me. This is who I am. I'm a litigation and labor and employment partner at Greenspoon Marder. I've been doing the legal thing for over 20 years, and I have somewhat of a unique background in that I've been at a law firm. I've been in-house for about 10 years, which I think hopefully gives me a perspective that some other attorneys don't have as to what you all are dealing with and trying to get some practical as well as legal answers. And I have a background in the military, still doing the Air Force JAG thing, and I've been doing that for about 20 years as well. And I think that that triple crownness gives me somewhat of a unique perspective on things, and hopefully I'm able to share some of that with you today. And I guess before we get started too, I strongly encourage folks to ask questions, make this less of a monologue and more of a interactive presentation. Please use the Q&A function at the bottom of your Zoom screen. I'm sure you're all fairly much more of an expert on the Zoom thing than maybe I am, but please ask questions as we go along. I think it'll be much better for everybody if I'm able to answer some of the specific questions that you may have. And if I don't get to the questions, happy to circle back with you after the presentation. But let's kick this off. And I think one of the major reasons or impetus for having a lot of potential changes over the next 4 years at least is because we have a new Secretary of Labor. Marty Walsh has been appointed by President Biden as the Secretary of Labor. And this, to me, has gone fairly under the radar, where a lot of changes start with this position and will trickle down to you as the employers or companies out there in the marketplace. So for starters, what does the Department of Labor cover? It includes 3 major divisions: the Wage and Hour Division, OSHA, and the OFCCP programs. So if you have any the wage and hour issues, workplace safety, the compliance with your pay programs, all those things are covered under the Department of Labor. And Secretary Walsh, for those of you that don't know, comes from a union background. So for those companies that have unions or dealing with them, a totally separate issue as to how this new administration is going to handle the National Labor Relations Board and things in the union sector. But as a former union president and as somebody has advocated on behalf of the little guy, on behalf of the employees, we anticipate some fairly significant changes in how the Department of Labor and its subdivisions are going to be run. And it's already started. There's been a lot of, in the new bills that have been passed, budget increase for the Department of Labor, and they've made no secret about where that new money is going. It is going to the staffing, and specifically there's going to be enforcement programs. So what this most likely will mean is that the Department of Labor is going to be staffed up to be able to do more wage and hour audits, more OSHA audits, and more OFCCP audits. So the question, and we are actually getting our first question, so I'm going to take that one. But one of the questions that just came in is, what recommendations or steps should we take as a company to be prepared for the audits? Which is a great question, and it segues right to what we're about to hit on here. So obviously make sure you're ready and prepared, but what you can be doing and what you probably should be doing at this point in anticipation of some of these audits is to go through your books. And specifically, I'm advising a lot of my clients in Colorado and California and across the country to make sure that they're going and they're doing these wage and hour audits. And what I mean by that is twofold. One is looking at job descriptions, making sure that your employees are actually doing the jobs that the job descriptions say they are, and then also making sure that the job descriptions are properly aligned to whether the individuals are an exempt or a non-exempt employee. You also want to probably do a second look at some of the independent contractors. Do you have them? Are they properly classified as independent contractors? Under the OFCCP audits, you probably want to make sure that there is some type of analysis that everybody's being paid fairly and equitably. In Colorado, they came up with a new law this past year that if you're not doing those wage and hour audits, that you're not getting the protection that you may want or need if you ever are sued under some type of pay disparity or pay equity lawsuit. So there are advantages to doing them, both from a fairness, which right by your employees, but also from a liability and self-protection. You want to make sure that you're doing these type of audits in advance before you get hit with any sort of, before the Department of Labor comes knocking, and certainly before you get any lawsuits filed against you. All right. What else is going on in the Department of Labor? So almost right off the bat, they are trying to unwind some of the rules that went into play under the Trump era, and these Trump era rules were very company employer friendly. The first one has to do with rescinding the independent contractor classification. And under the Trump administration, it became easier to classify somebody as an independent contractor. This new proposed rule, and right now it has not been finalized, but this new proposed rule that the Wage and Hour Division has recommended or put forth will make it extremely difficult to classify any workers as independent contractors. And you'll put the ABC test there, and that is in place in California and has been in play in California for quite some time. But under the ABC test, which is what this new rule is more or less mirrored after, you need to fit these three criteria to have somebody classified as an independent contractor. And number one is free from direction and control. So if the employer is given any sort of guidance or telling the individual how they should do their job, in what manner they should do their job, whether they're providing equipment to the individual to do the work they need to do, checking in on them, giving them any sort of feedback, any sort of grading or performance reviews. Those are all things that would go to an employee and not an independent contractor. Next one is kind of big too, that this is the one that has stumped a lot of companies across the country, is that the worker performs work that's outside the usual course of the hiring entity's business. And what that means is if you have a software company, for example, and you hire a software engineer to perform work to help supplement the rest of the workforce, that's not work that is outside the usual course of your business. So you would need to have somebody, a landscaper, for example. If you hire a landscaper, maybe they are an independent contractor for you as a software company. But if you're hiring other people that are doing the computers and the software and the programming, that's probably not outside the usual course of your business, and that individual is not going to be properly classified as an independent contractor. And finally, the worker is customarily engaged in this trade, and what that means is that they have that's their job. They do this particular work for you and for other companies, and they have the flexibility and the discretion to work for as many companies as they can, and they're not bound by any sort of exclusivity. So that's pretty significant. And if that does happen, it can impact a lot of companies out there that rely upon the independent contractor, independent contractors to help them perform and operate their business. And once again, please feel free to submit any questions that you have in the Q&A feature. I want to make sure everybody is tracking this and responding to what you all are thinking out there. Second rule that is proposed to be rescinded is the joint employment rule. And this is essentially, it's hitting the franchisees and the subcontractors as well here, where if you are a lead corporation and one of your affiliates does something wrong or is accused of doing some type of bad act, under the Trump era, you probably would have some protection as to whether the plaintiff in that case can go after you for damages as well. Under this Biden era joint employment rule, you would no longer have that protection. You would be fair game for the plaintiff to sue both the direct entity that is doing the alleged harm as well as the parent company. So once again, that's could be problematic and drag companies into lawsuits that they would not otherwise be subject to in the Trump administration. And then finally, this paid program, the payroll audit independent determination. Excuse me, I'm not sure how many of you have signed up for this, but what this is a way for you as a company to self-report to the wage and hour division. And if you are aware of any sort of wage and hour violation that you may have committed, or there's an allegation out there, if you self-reported, then there's a way for you to simply pay back the employee who had not received the adequate compensation and not really have much of the damages or interest that would have accrued otherwise. And it was a relatively easy, quote unquote, way for an employer to get out of hot water when it comes to wage and hour violations, because as you know, those tend to double and triple and get quite expensive as the case moves forward. And this was a way for that to happen and to have some protection, and that is no longer in play. Get another question here, and just so everybody knows too, the questions that are submitted, they're submitted anonymously, so no way for anybody to know who is submitting. So there's no such thing as a dumb question. And if there is, then we have no way of tracking it back to you. So you're probably pretty safe. So feel free to ask away. So the question again, what happens for independent contractors when you contract with a company, not an individual? For example, an outside marketing company to guide social media, when your company would need to give direction as we have the materials to complete their job, how would that work with the potential new independent contractor rule? So hopefully everybody understood that. I know I sped through the question. It still would have an impact on you, and it's one step removed. So you probably have some protection, and hopefully your company is doing, or the company that you're contracting with has some of those type of ways to get out of under the ABC test. And so there's there's a lack of direction, lack of control, and that they're also not in the same business as you. So that would work, but you still have to, it's still going to apply to you, even if it is with a company and not an individual. Another question, for the liability of claims against contractors, what could specifically be alleged against the company? General professional claims, employment claims, anything else? Good question. Yeah, so you can get several different types of claims. Number one could be that you owe the employee wages, if they were getting paid on some type of fee structure, or as the project got completed, but they really, had they been an employee and quote properly classified, they would have been overtime eligible. You owe them for all the FICA and Social Security claims or Social Security withholdings that they would have received, that they were responsible for as a 1099 as opposed to a W-2 employee. So you'd be responsible for that. If there was somebody similarly situated at the company that was an employee, if they were getting bonuses, if they were getting benefits, those would also be things that you'd be on the hook for. And then just from an employment claim perspective as well, if you are mistreating them, then you would not have the protection of saying that they're not your employee. You would be on the hook to make sure that if there is an allegation, you would be the one who would have to not harass them, not discriminate against them, and treat them fairly. But good questions. All right. So next, I'm sure as the rest of the world, your company has had some impact as to its workforce during this pandemic. And that could have or will have some type of impact on your FLSA qualifications. For example, if you have exempt employees, so salaried employees who are classified under one of the exemptions, but because of their new job responsibilities or the lack of responsibilities or how their job has shifted, they are no longer properly classified as an exempt employee under the Fair Labor Standards Act, then at that point, they are overtime eligible, and you would owe them for anything in excess of 40 hours a week, or if you're in a state that has the daily overtime rules, that could be applicable as well. And then that has in turn some implications on bonus potential. So you want to make sure that if people's jobs have changed, if their job responsibilities have changed, that is not somehow impacting their exemption or non-exempt status. Additionally, people are going to start returning to work. So if their job responsibilities that they had when they initially were there, then they went on the pandemic and worked remote, and now they're coming back, but things have shifted because maybe they're not working in the same office, or they have some sort of hybrid approach where maybe they're working remotely some days of the week, or they're in the office on other days. That can all have some type of implication as to their exemption status, but also how they're being paid, where they are working, where they're not working, whether they're going to work, whether that's going to qualify as compensable time, whether it's not compensable, if they're getting hurt, if they're covered under workers' comp. So all of these things should be thought through and see where your potential risks or liability may be. I would encourage everybody to audit the roles and to know where they are now and where you anticipate the roles going. To the extent that you need to update your job descriptions, I think now is the time to start thinking about that. If people's responsibilities have changed, that needs to be reflected in the job responsibilities. Have your employees sign off on those, that they are acknowledging that their job has changed and they no longer are doing the 10 things that they initially were doing when they took the job, but because of how the workforce has had to adjust and modify over the pandemic, that is a new world that we're living in. And then finally, update your policies and your handbook. I think those are super important, and we want to make sure that employee handbook or the policies that you have are a living, breathing document that needs to be updated and changed based on the working conditions that you all have. And I think people's expectations have changed and where they're working has changed. So we need to be somewhat fluid in that. Okay, I'm getting some questions. I think it's going to the chat, so bear with me for a second. If a contractor is reclassified as an employee, will the employer be liable for workers' comp on past payments? Potentially. And if everybody could too, just as a reminder, please put your questions in the Q&A. This way we have a good way of tracking the questions. The chat goes away, I think, afterwards, but the Q&A is a way for us to track those. So if you don't mind, throw them there, but I'm happy to answer the ones that are in the chat. So the short answer, Paul, is that yes, you would be potentially on the hook for premiums. The courts will want to make the employee whole. So if the contractor has been the one to take out payments or make payments on past workers' comp premiums, and they were incorrectly classified as a contractor, then you're probably going to be on the hook to make those premium payments. Another question: how much impact do you think this will have on ADA claims? as to work that should be performed at the employer's home versus location versus home? Really good question. I think it could have an impact, and it's going to be a fairly significant one. And what I mean by that, and just for those of you that let me back up. Under the ADA, you have an obligation to engage in the interactive process with your employees to the extent that they're bringing up some type of claim that they need an accommodation. And if one of the requests that they're making as an accommodation is to work remotely, I think this question is really good in that, or insightful in that it's going to be hard to say that you need to be in the office to perform the essential functions of your job if for the past year, 6 months, 9 months, they've been doing it at home. So we'll need to think through a little bit as to how to justify from a business perspective why it's important for them to actually be in the office, whether it's 5 days a week or at least a couple days a week. But I think it's a really good point, really good question, in that you're going to have to jump through some additional hoops to potentially justify why an employee needs to actually be in the office to perform their jobs. For updates to federal regulation, so sorry, a couple of new questions that came in. Updates to federal regulations for employment. Where can we check on a regular basis to see when new regulations are put in place? They're published out there. You can go to the Department of Labor website. Those are always they're published out there. You can ask me. I'm happy to give you some of the updates that we track those regularly. But if you want to do them on your own, there are updates that are shown and published on the federal government's website, and I encourage you to look there. Would a salaried employee be subject to overtime if their role is in administration and they report to a supervisor and the company's owners? Getting into specifics, I would probably need a little more detail on that. But if they're doing administration, they don't have a lot of discretion to make independent decisions, and they're not supervising people, then based on the very limited information and facts that the question presented, I would guess and hypothesize that they would probably need to be classified as an overtime eligible / hourly employee as opposed to a salaried one. But happy to have that conversation with whoever that anonymous attendee is offline. Another question, follow up on the ADA question: should job descriptions be updated to indicate which are potential work from home versus employer location only, or is that best left to the interactive process? Another really good question. I think if you have in the job descriptions why it's important, it certainly helps. And I would love to have that as a resource or a way to kind of look back on the job description itself as a way to justify why the employee knows or should have known that this is a position that needs to be in the office. Doesn't mean that's going to be our get out of jail free card, but it is a good way to at least be able to push that conversation and show that they should have known that this was a position that required to be in the office. Great question. Let's go on to the next slide. All right, vaccines. I'm sure you have seen this out there and are getting questions as to how you should handle it. And one of the issues that you may or may not have thought about is whether or not if your employees are getting vaccines, whether that is compensable time. And I think it really comes down to two different things. One, is it state specific? And are some states saying that you need to get paid for the time that the employees are taking off to get vaccinated? But number two is, what type of messaging are you telling your employees? If you're strongly suggesting that they should get vaccinated and you think it's a really good idea and it would help those around them, then maybe it's not compensable. But if you are requiring it or mandating that before they return back to the office that they need to get vaccinated, then I think there's a very strong argument that that time is compensable and that they need to be paid for the time that they are getting vaccinated. And then the third part, and I should have said 3 parts there too, I think it's going to be, it's one of those things where from a branding, marketing perspective, it may be the quote right thing to do. And as long as your employees, you trust them, they're not abusing it, they're not taking advantage of that, which I'm sure none of your employees would ever do that. But if they are trustworthy, then it may be the quote right thing to do to have them get vaccinated and to not penalize them monetarily if they do that. Next question I get a lot now is the screening and how whether that is compensable time. So if you are taking temperatures or having individuals fill out questionnaires as they get back to work every day to confirm that they're not exhibiting any sort of symptoms related to COVID-19 or are sick otherwise, there is some question out there whether that time in and of itself is compensable. And how are you handling that? And there have already been lawsuits. Both Walmart and Amazon have been sued by employees saying that the time that they are spending getting screened should be compensable. So there's been no final disposition on those lawsuits. It's still in the very early stages, but certainly making a lot of news or press in the wage and hour world as to these are class actions. They could be pretty significant, 5 minutes, 10 minutes there. But when you multiply that by the number of employees that are getting screened, by the number of days that it's happening, it very quickly adds up. And those wage and hour cases, when you add in the liquidated damages and attorney's fees, it all becomes pretty expensive. So you just want to make sure that you're handling it the right way. Review whatever pay practices you have. If there are policies in place, make sure that those are updated. But the world that we live in now is requiring us to make sure that we're somewhat fluid and adaptable into making sure that we're honoring the FLSA and more importantly, from an employer perspective, not dealing with or having employees file claims or lawsuits or getting the DOL involved to have them audit you. All right, so I didn't save the 5 minutes that I was hoping for at the end for questions, but we do have a couple minutes here. So to the extent that I have not answered any of your questions, please submit them now, but I know we're coming close to the half-hour mark, and I want to be respectful of everybody's time that has joined. And if you do have, if you can't think of a question now and one comes to you later, the next slide, I think, has my contact information. Please feel free to reach out to me. As sad as it is to say, I'm a geek when it comes to this stuff, and I enjoy talking about it and love to kick it around with you if you do have questions. So I would encourage you to email me, call me, whatever, write me a letter if people do that anymore. That my address is there for some reason. So if you want to communicate with me, please feel free to reach out. And I appreciate everybody making the time today to attend this. And thank you.